Great. So thanks everyone for coming to this talk by Francesca and I on professional negligence and AI. Um, it's obviously AI is sort of growing exponentially, and I'm sure you've all either seen it used in your work or used it yourself in your work. So we thought it's throwing up some very interesting questions within the realm of professional negligence. We know that the Master of the Rules, Jeffrey Voss, gave a recent talk on it, which we both attended, which was very interesting, and Francesca's going to talk about that. And we thought it would be quite helpful for clients and practitioners to dive into some of the detail about what the use of AI means for professional negligence claims. So in this talk, we're going to talk about, first of all, what is AI? What do we mean when we talk about it? Secondly, how and why do professionals use AI? Third, what is the present state of the law, English and Welsh law on AI and the use of AI by professionals? Um, Fourth, what's the position of professional regulators within this jurisdiction? And then lastly, about the EU's AI Act. And then we're going to have a quiz with three case studies involving the use of AI by professionals within different industries. And we're going to open up the floor to to a poll, I suppose, where you get to vote on whether or not you think that the professional in question has been negligent. And then we'll have a quick discussion about that. And anyone who has any questions can get involved at that stage. Um,
See, you thought you were just going to be able to eat your sandwich,
yeah,
but no, we've got
yeah,
tests. I'm interrupting only because I can see
yeah.
that someone's got their hand up.
Oh, yeah.
Is that about some technological issue that you're having, or is there a question that you want to ask us?
I'll allow Louise Walker to
Yeah,
talk.
no, no, nothing. Maybe it was just
If you've got a question, Louise, I think probably the best way to do it is to put it
in the chat box. I was going to
in the chat
say,
box,
and
if that's
same goes for
possible.
you, Bethany. If you've got a question, some people have sent in questions in advance, which we'll deal with.
Yeah,
But if you've got a question that comes up during the course of the talk, please just pop it in the chat box and we'll try and get to it.
brilliant.
Thanks. Sorry, Connor.
No, that's all right. That's very helpful. Thanks, Francesca. Okay, so what is AI? This is a difficult question. You probably all have had experience of using ChatGPT or Google's version Gemini or Microsoft's Copilot. Essentially, generative AI, of which those are examples, differs from previous AI in that previously machine learning models would learn to make predictions based on data it had. So, for example, if you give it a million X-rays and tell it which ones show a sign of a tumor and which ones don't, it will be quite good at picking out that one. Or if you give it a list of borrowers and tell them which ones are more likely to default on a loan, it will be quite competent at replicating those decisions and outputs. Whereas generative AI differs in that it can create new data as opposed to making predictions based on a specific data set that it already has. Um, it has the appearance of human-generated content, but it's important to remember that it's not. And I've given this example of a mechanical Turk. I don't know if anyone knows what this was, but it was a sort of 18th century device which looked like a machine, and it was a sort of a chess device. So it had a sort of a mock chess player who would play and defeat virtually any opponent that faced it. Um, Ultimately, it turned out that it was a fraud because there was a chess master hiding inside it and controlling the machine. So it might sound a bit farcical or conspiracy minded to talk about mechanical Turks when we're talking about AI systems with these sophisticated technology companies. But I don't know if anyone saw, but there was a recent story in The Guardian published this April about Amazon's AI-powered cashier-free supermarkets that they've launched. And apparently, Amazon was secretly using thousands of workers in India to simply watch these shoppers in its stores passing through these items. And the suggestion is that they weren't really being open about what they were doing because they were holding themselves out as this sophisticated AI process, whereas it was really just someone hiding in the machine controlling it. I don't know. I'm sure Amazon would dispute that, and I'm not sure to what extent it's true. But the story mentioned a similar issue with Facebook's Smart Assistant M, which apparently was simply referring, again claimed to be AI, but which simply referred complex queries to real people. Um, so I don't want to stand here and lecture you on how this sophisticated technology works, because the truth is I don't know. And the truth is I don't think any of us really knows how it works unless we're at one of these companies and we can see behind the box. And I think you just need to remember that when you're looking at professional negligence cases and AI, none of us really knows how this works. And I think if you place too much trust in it, in the worst case scenario, you'll end up with another Post Office Horizon software scandal where everyone just trusts the computer and thinks, well, it's a sort of it's a machine. It can't go wrong. That's the kind of situations that professionals are going to find themselves in trouble. Um, so how and why might professionals use AI? Well, lawyers are already using it, and Francesca and I have recently been signed up as quote unquote guinea pigs for one of these providers' uh, software, which allows you to effectively upload hundreds of documents on a case, search that database, which you can probably already do using just OCR technology and Control Find. It allows you to review documents, so you can ask it to say, find clauses relating to a given issue, and it will do that. Um, you can even allow it to draft documents such as pleadings. I haven't seen that done effectively yet, but conceivably it could be used for that. And even to prepare a deposition, which in English is examination of a witness. So big claims, and obviously if they can live up to it, enormous gains in productivity. So obvious reasons for law firms and barristers to use AI. Similarly, with doctors, it's something I've mentioned, and you're already probably familiar with it, is the value of AI in radiography and imaging. But beyond that, obviously diagnosis and tests, which is a similar sort of field. Beyond that, to risk assessments for certain patients, it could be psychiatric patients. If an AI can scan their medical records and identify, as with at high-risk borrowers, identify patients that are at risk of harm. It could be incredibly valuable for that, but obviously if it doesn't work, the scope for damage and loss could be enormous as well. Financial professionals are already using it for financial modeling, risk assessments, regulatory compliance, and market analysis, and even algorithmic trading, which again I'm sure isn't used to any of you. And then surveyors are using it to automate cost estimates, to schedule and reschedule projects, and with their CAD design and so on. So obviously the major reason why professionals use it is to increase productivity and reduce costs and effectively increase profits, which is an inherently reasonable thing to do. There's nothing wrong with that. So there is valid scope for the use of AI, provided it's done safely and with proper supervision. Um, None of this changes the law, so far as I'm concerned, in England and Wales. You still have the classic pattern of an analysis for an AI, for a professional negligence claim, which is duty standard, breach according to that standard, and causation. You're still going to have to look primarily at express duties contained in the contract if there is one. If not, what sort of what what is implied by customer trade, the fiduciary duties. So in particular, the duty to be open and honest with clients, um, and then the statutory duty, which is of course the reasonable care and skill, which is implied by statute. I think the other point to make about the fiduciary duty is the duty of confidentiality. I've mentioned at the outset ChatGPT 4 and Gemini and so on. I can't emphasize this sufficiently, that you must not ever put in client data to those machines, because these are large language models. As soon as you put something in, it consumes it and absorbs it into its sort of data content. And it could well conceivably spit that out if another lawyer somewhere else, or even just a non-lawyer, if anybody enters a query and you said, my client with this name and all of these medical records you put into it, it could well spit that out in an answer to another question, and suddenly you're in breach of your fiduciary duties to maintain confidentiality. In addition to other sort of data obligations. Um, so as I say, it doesn't change the state of the law. I think the key battleground in these professional negligence claims is going to be the standard of care. So primarily, what is industry practice? That's going to be something of a moving target. As I say, it's increasingly the case that those are using AI. It's increasingly the case that financial and medical professionals are using AI. And that is, I think, going to change what's expected of professionals. It used to be the case classically that judges wouldn't expect solicitors or lawyers to know every statute in existence. And of course, that's going to continue to be the case because simply it's not possible, it's not reasonable in terms of the costs that it would impose on solicitors, even if it were possible, or barristers. But increasingly, what would have taken a couple of days of research trawling through all the conceivable, well, I suppose peripheral statutes and regulations, if that can be done in a couple of seconds with an intelligent AI assisted search that will throw up the relevant, Schedule 6 or to a very long statute, that is the kind of thing that will increasingly be considered a reasonable to expect from
Happy
it.
radio to everyone. Will it be possible to receive a recording and/or the copy of the slides at the end of the presentation?
Yeah, we've just got a question. Yeah, we'll send out these slides, and as I understand it, this will be made available on YouTube afterwards, so anyone can watch this again. So that's the point I'm making about industry practice. It goes the same for medicine. Increasingly, where it's possible to improve diagnoses, particularly in obscure diagnoses that would be difficult under present sort of available resources. Increasingly, it will be expected of a reasonable medical professional or a reasonable whatever the profession that they use these tools to expand the scope of their knowledge and increase the standard of the service that they provide. Expert evidence, it's usually the case that you always require in prof neg cases. It's usually the case that it's not required in solicitor or barrister negligence cases because generally the judge will have been a solicitor or barrister and they generally know how those industries work and what's reasonably required of those professions. I can see that changing with AI prof neg cases because as I've mentioned, it's changing so rapidly at such a rapid pace that judges on the bench now or who've been on the bench for even a few years won't have practical professional experience of using these AI resources that I talked about, that Westlaw and LexisNexis are now making available. And I think they would be assisted by the use of contemporary expert evidence from those industries. Other factors, the likelihood of harm, the gravity of the harm, and of course, cost considerations, which, as I say, are going to be a major consideration in whether or not it's reasonable to expect professionals to use these AI tools that are now available. So the key points, as I said, there's no prohibition on the use of AI. You might even be aware that some senior judges, Lord Justice Burse, has openly admitted to using it to draft part of a judgment. Obviously, he knew the area of law. He was able to review it and ensure that it was all correct and accurate. But these senior judges, Sir Geoffrey Ross, they're all quite open about this being a good thing for the industry. So not only is there no prohibition on it, but I think you can expect judges to expect professionals to make use of these tools as they become increasingly reliable and helpful. And as I say, the key sort of issue for me is going to be the industry practice and standard as your guide for what's reasonable and what's negligent. I'm going to look quickly at the position of the professional regulators on this. As you'll all know, breach of professional obligations in terms of regulatory standards it's not the same thing as a breach of a private law obligation to a client. But nevertheless, I always think it's a very useful starting point in terms of what the appropriate standard is for a professional to follow. So I thought it would be helpful to look at what some of the key regulators in this jurisdiction have said about AI. So starting with our regulator, the Bar Standard and the Bar Council, which isn't our regulator, but is a sort of trade union body, but nevertheless sets out very helpful guidance on standards for barristers, which would carry significant weight. And what they say is, I think this is the key point, the lawyer is answerable for the work product. So you probably all know about the case recently in North America, where a lawyer handed in written submissions which simply made up cases which didn't exist, but which had genuine case references, and then had opposing counsel thinking they were losing their minds, scrambling around, and the judge probably in the same position, trying to find these cases. And ultimately, it transpired that they'd punched this case into ChatGPT, and it had spat out a very convincing answer that was just entirely hallucinated and fabricated. In those cases, a lawyer is obviously going to be answerable for the output of their work. And it's an obvious warning. I'm sure none of you would have done that, but it's an obvious warning for what would happen if you did so, or if one of your clients did so. And that's a case where you'd have a pretty obvious negligence claim against your lawyer. The core duties continue to apply. They use this term black box syndrome, which I think was that mechanical Turk point I was making earlier. None of us know, and this is certainly our regulator's position. We don't know what's going on inside that box, so we can't trust it. We can't rely on it if we can't understand it and if we can't explain it. It's the point I've made, and the Bar Standards Board is alive to this and is warning barristers about it, that you cannot share confidential or privileged information with a large language model system, LLM system. There's the duty to keep abreast of the CPR. So as I understand it, our CPR hasn't yet addressed the use of AI, but according to the Bar Standards Board, apparently Manitoba, which is a province in Canada, has already introduced within their CPR some reference to AI and its use by professionals. So it's worth keeping an eye on our CPR to see how that develops. They make the point about the risk of bias perpetuation. So obviously these AI systems are trained on available data and work product, but there's obviously in a lot of that data there will be sort of bias against certain minorities, against women, and so on. And it's important to be aware of that and not let your use of AI perpetuate bias. And then lastly, the Bar Standards Board has made express reference to the EU's AI Act, which I'll come to later, which categorizes certain use of AI tools in legal practice as high risk. So we'll come back to that later, but it shows why, even though that legislation doesn't directly apply to this jurisdiction, it's still something that regulators are going to have an eye on, and that professionals should be aware of in terms of how it sets general standards for industry. As I say, the core duties apply. These are probably the most important ones. So a barrister should always consider how these duties will be affected by their use of AI, as I'm sure they would. The Solicitors Regulation Authority adopts 5 principles set out in the government's national AI strategy, which I'll come to later, so I won't duplicate now. Effectively, the other points they make are that firms have a duty to ensure clarity over responsibility for errors in systems. So whether that's the responsibility of the firm or the provider of the AI system that they rely on, the importance of testing systems prior to using them, the importance of training their staff in the use of AI systems, and of documenting and being able to explain the use of AI at each stage. And it gives this helpful sort of analogy of an enthusiastic but unreliable teenager, or a bright but unreliable teenager. The other way I've seen it phrased by a lawyer, Dan Needle, who I follow on Twitter, is a very green trainee who also happens to be an occasional pathological liar. And I think that's I couldn't put it better myself. So I think that's the way professionals should be thinking about AI as a default. And then the last point about for solicitors to note is that this SRA apparently has plans to develop a sandbox for firms to test new AI technologies. I have to say I don't know what a sandbox means, but I imagine it means a sort of a safe environment to test these products. The General Medical Council, nothing you wouldn't expect. It recognizes the value of AI systems in diagnostics and scans. It emphasizes, as with the professional regulators for lawyers, the duty to use professional judgment and the importance of training and ongoing testing. And then the Financial Conduct Authority, they say they've got a technology agnostic, principles based and outcomes focused approach to regulation, which I think all of these points that one regulator has made, I think the other regulators would probably agree with. And it refers to those five key principles which were set out in the government's white paper on AI regulation, which the SRA I mentioned also made reference to. And I've set them out there, all pretty obvious: safety, security, robustness, transparency, and explainability. Question how much it's possible to explain or be transparent about this black box that is AI. But at least if you can say, as a financial professional, that you've tested this model, you've set up sort of appropriate systems for reviewing the output of AI systems, then that will go some way towards satisfying that objective. Accountability and governance and contestability and redress. So this is something that's been in the news recently about transparency for banks and financial service providers about how they treat customers. Effectively, it's not enough for financial service professionals to simply say the computer says no. Often their duty to clients will extend beyond that to allowing them to have an answer really from a human being as to why they're being treated in a certain way. And then lastly, this EU AI Act, which has come into force in August, and is the provisions of which are going to be gradually introduced over the next 6 to 24 months. At the outset, it's important to say that this is a sort of public law provision, so it doesn't really give private rights to clients in the way that that the statutory implied terms would in England and Wales. But nevertheless, it applies. I think it's primarily aimed at the big sort of tech firms who the EU is concerned about their impact on democracy and the rule of law, so spreading misinformation, that kind of thing, subliminally influencing consumers and members of the public in a democracy. But it also applies to deployers of AI systems. So those could be, I mean, any sort of business in the UK that provides a professional service which is then used or consumed in the European Union will be affected by this. So I think that's important to remember. But the other point to remember, and again, this is something that the Bar Standards Board has expressly made reference to in its guidance, this concept of high risk systems, in particular in the administration of justice, also in sort of areas like PPE and stuff, medical products. Those are obviously high risk areas where you can cause serious harm to people's fundamental rights. And they talk about the duty to test and review continually systems, which, as I say, was echoed by the SRA, by the FCA, and also to establish risk management systems. So, as I say, it will affect businesses within this jurisdiction who are providing services to the EU. But more importantly, I think it's going to have I think it's sort of lead the way. I think it will lead the way in standards, because I think other jurisdictions, including England and Wales, are going to look to the standards that are expected of and provided by professionals within the EU and think, well, if they can do that, and if it has all of this benefit for consumers and for the public, then why is it unreasonable to expect that professionals within this jurisdiction provide professional services to the same standard? So that's my sort of whistle stop tour of AI and professional negligence. I'm going to hand over to Francesca now, who's going to pick up on this theme about, well, the obligation to use AI that is increasingly being expected of professionals.
Thank you so much, Conor, for that, which actually wasn't a whistle-stop tour. I think it was a really useful summary of the key regulatory underpinning for what we're now going to discuss, which is really how professionals, in particular lawyers and doctors, but all professionals, are going to approach the use of AI and how that's going to affect the law and practice of those of us who deal with a lot of professional negligence work. And the slide is titled "Damned If You Do, Damned If You Don't." And that's really stolen from the lecture given by Sir Geoffrey Voss, Master of the Rolls. And the full text of his talk is actually available online if you Google it. And I encourage you all to have a read, because it's an interesting esoteric exposition of that tension between the way that professionals have been approaching the use of AI and the liability risks that emerge from that use. So we have to think about how the courts are going to approach professional negligence claims where AI have been used, but also to appreciate the fact that because in the law of professional negligence, we do deal with reasonable standards of care and what a BOLAM compliant, reasonable body of similar professionals would do, where, for example, the use of AI is widely being used to diagnose, for example, whether a skin defect is cancerous or not. A doctor may well be liable in professional clinical negligence if that tool was available and widely used and relied upon, but they didn't use it. So they might be liable for not using it at all. Some of you will have heard on the news in the last couple of days this amazing story about the separation, the surgical separation of conjoined twins in Turkey. And I heard a very interesting interview with the lead surgeon on that, who explained that in that surgery, they used something called mixed reality. Sounds amazing. But what actually happens is that they overlay onto the imaging of these particular patients imaging derived from millions of data sets about exactly where, for example, blood vessels are going to be. And so they can plan every second of the surgery before they've even started it. And then the whole thing, which I think it lasted 13 hours or something like that, goes like clockwork, because they're able to overlay mixed reality, virtual reality on the reality of what they're operating on. And that raises for me all sorts of amazing ethical questions, because on the one hand, it's incredible. Of course, we should be using technology to save the lives of children. But equally, how does that feed into an assessment of the applicable standards of care? Is mixed reality going to be something that's used in a widespread sense in surgery? Is it going to come for other types of technical operation? I don't know, but I think we can all agree that this is technology that's advancing at an incredible rate, and we're going to have to come to terms with it and learn how to grapple with it. I've suggested on this slide that there are still good arguments for being very cautious about the use of AI. We know that it's prone to bias. We know that it can hallucinate. It can be incredibly inaccurate. Conor already mentioned that highly embarrassing case in the US, where it made up case law that just didn't exist. So you've got to be really careful. And of course, we know that the public needs legal advice and legal decisions from judges, from lawyers, that they have complete confidence in, because the whole point of lawyers is that they resolve disputes. So you have to be able to rely on it. And if we combine the fact that one has to be able to rely on it, and yet AI technology is unreliable by its very nature, then we've got to be super careful about using it. It's not regulated to the same extent in this jurisdiction yet, although I agree with Conor that the courts are likely to look at the EU AI Act as a really useful framework for the guidance and the standards that are expected. But if we're going to use it, we've got to do it with the greatest care, the greatest circumspection, and we should be very wary about it. The counter to that, of course, is that clients who pay for professional services, and I'm talking mainly about lawyers, but also financial services, accountants, and so on, are going to be unwilling to pay for lengthy and onerous tasks to be completed by humans, by paralegals, by legal executives and assistants, when those tasks can be done better, quicker, and much more cheaply by an AI. And Conor already mentioned some of the things that AI is being used for: research, formulating chronologies, drafting contracts, searching thousands of pages of contractual documentation for clauses, that sort of thing. And we also have to bear in mind that whilst lots of clients are not going to be able or aren't going to be prepared to pay for those services, large language models are improving all the time. They're going to become more reliable and better at their jobs, and they'll be integrated with database technology so that these inaccuracies and biases that we're familiar with are going to be reduced and eventually, hopefully, phased out. So what can we do about this? The conclusion that the Master of the Rolls reached, and I agree with him, is that there are going to be problems if you adopt AI hook and sinker, damned if you do. And there are going to be equally serious problems if you shun or ignore AI and pretend it doesn't exist because you're too scared of it, damned if you don't. And I think really one way of exploring that tension in practical terms is to come back to something that Conor mentioned. Well, experts. We're all familiar with the use of experts in professional negligence cases, particularly clinical negligence, but also accountants, surveyors, architects, and so on. In cases that involve lawyers, we don't use experts. But when a case is going to come down to whether or not it was reasonable to use a certain AI product or to rely on it, I think that Conor's right. We're going to see judges particularly consider that it would be useful to have expert evidence before the court in compliance with Part 35. Who are those experts going to be? Are they going to be lawyers themselves? Are they going to be people who have experience with technology, perhaps even employees of the developers of the software? I don't know the answers, but I think those are relevant questions that we should all be thinking about quite hard. And I say all of that because professional negligence lawyers like us are going to be at the epicenter of these issues. We know that these machine learning technologies are getting better all the time. We know that they're going to be used more frequently all the time. And we know that the technology is going to be used in circumstances where clients are going to refuse to pay huge bills for work that could be done more quickly. And what's really special about professional negligence lawyers is, of course, that we look at the law surrounding how other people do their jobs. And we know that AI is going to have that profound effect on how other people do their jobs: doctors, lawyers, accountants, and so on. So before we come to the case studies, I'm just going to formulate that in a little more detail. We know that machines are never going to operate in the same way as the human brain, but we are going to need to adjust fast to their capabilities and recognize where they can be useful and where we need to be cautious. Real intelligence probably requires knowledge, okay, not controversial, reasoning and communication. And we know that the weakness at the moment of AI, particularly at the moment, is in human reasoning and empathy. And those are both very important things when we're dealing with professional negligence claims, which often involve the reputations of professionals who've worked their whole lives. So I think we've got to be really quite cautious about this. But we also know that many aspects of the rule of law and the concept of justice itself in resolving the disputes that arise between normal people depend upon things like empathy, conscience, guilt, and our reactions to suffering, loss, pain, damage, all of those things which are the constituent ingredients of tort law. So how worried should we be in a world where we know those things are very important, but AI hasn't quite caught up? Well, we can't afford, I say, to ignore it or to dismiss its use or dismiss its capabilities just because we're scared. And we also can't accept that it should be used in a sort of swinging way just because clients don't want to pay for proper care and attention to be paid to their work. Conor is right. Standards of service have not been affected. And we'll all recall those cases like Les Jean-Van, where the standard of care of a professional is not affected at all by how much the client paid. In fact, even if a service is provided for free, it still must be done to the requisite professional standard. So we've got to be careful about that. And we've got to also recognise that whilst humanity and empathy are going to be the last aspect overtaken by AI, we have to learn to use it in a sensible and constructive way. And I think lawyers therefore need to be able to explain the legal position to clients, even if the initial advice and decision making is undertaken or assisted by machines. And I say that because, of course, there are already things that AI can do much more quickly and cheaply than lawyers. For example, summarizing large data sets, those things that we've already discussed. I'm very, very cautious of the fact that it could be used to draft judicial decisions, because I really regard that as still being entirely within the prism of what the general public at least would expect a human judge to do. Just coming to the statistics, though, briefly, if an AI can produce legal advice that is, for example, 98% reliable, that might compete very favourably with the best of lawyers. But how can we know? By what parameters can we determine that a professional is using all the due professional skill, care, and diligence that they are expected to use when an AI has a certain format and a certain data set and a certain way of working? And are we happy with it to be 98%? Are we happy with it to be 95%? How accurate and reliable is the advice and work that humans do anyway? So my argument, and I think this was also what I'm going to call him Mr. Justice Boss, but the Master of the Rolls said, was that the legal profession should adopt the middle ground. So professionals and others providing specialist services are generally liable under the law of negligence if they fail to exercise reasonable skill, care, and diligence in performing their professional duties. We know that. They are expected to adopt widely recognised practices and procedures, and I think the time will surely come in every professional field where those widely recognised practices and procedures will include the use of AI. So the things to consider if and when you're confronted with a claim of this sort, and I think it's only a matter of time before we all are, is what is generally available AI tools in that profession? What is being used? When is using reasonable skill, care, and diligence, when is it a requirement of that AI tools are known about and used or not? And when an AI tool has been used and it's been shown to be sufficiently reliable to make it equal to or better than the work of human experts or professionals, does that feed into a new recharacterization of the Bolam standards that we are all well acquainted with already? Plenty of food for thought, and I'm sorry that my part of the talk has perhaps raised more questions than it's answered. But I think those are all really important takeaways for anyone considering professional negligence claims that involves the use of AI. We can now move on to the examples that were, yes, there we go, the case studies. So Conor, you've got control of the screen. So I think what we were going to do is ask you all to read this.
Yeah, so have a read of this.
Yeah.
Sorry, go on ahead, and then I'll do a poll.
So, okay, so everyone reads it, and then we're going to pose the question on the screen, and I'd like as many of you as you feel able to answer it, and then we can discuss it. So can we have the widget, please, Conor?
Hopefully everyone can see that.
Oh, it's interesting.
This is from a real case, I should say.
Yeah. Okay, let's give everyone another 10 seconds.
Yeah, answers are still coming in. I'll end the poll in about 10 seconds.
Great. Come on, half of you haven't even tried. Give it a go.
I'll end the book because I think I can see which way it's going.
Yeah, I think I can see which
Although
way
it's
it's
not.
going as well.
Share results. Um, yeah, so
Okay, so we've got a 70-30% split. 70% of you think it was negligent, and 30% of you think it wasn't. Connor, what's the answer?
well we don't I mean it wasn't negligent originally. So this is a case from 1994 and the court held it wasn't negligent originally because it was quite a niche sort of area and this was just a general sort of practice city solicitor firm. Um, I mean, I suppose if we were to do a poll of our attendees, it would probably, I'd say not many probably use co-counsel or a similar sort of Westlaw
Yeah,
LexisNexis product on this basis. And on that basis, on the basis that our attendees are all, of course, reasonably competent professionals who set that standard, I'd say it's probably not yet negligent for the solicitors not to ask co-counsel, but I think there'll come a day when most city solicitors will use co-counsel or something similar. And if it's a sort of if it can be an automated process that just checks over things and makes suggestions, and if they'd used it and it would have picked this up, then I think given the negligent cost and the enormous value, I think when it costs millions for the unsuccessful client here in this case, it's hard to see how you could argue against the use of AI in those circumstances.
yeah. So
What
I mean, I really think that this is a question which totally ties into the things that we've been talking about. So we're looking for a BOLEM compliant test that a court will look at to consider what a reasonable body of professionals would do or what tools they would use. And I think at the moment, it would be a stretch for a judge to find that it was negligent not to use co-counsel or a similar AI tool. But I think that is going to change rapidly, and certainly in the next, I would say, 5 years, there's going to come a time when using a AI tool like co-counsel will be as widespread and mainstream as the use of other technologies, which we wouldn't even blink an eye at, like using Westlaw. Of course, you used to, I mean, I'm not that old, but you used to have to go to the library in a temple to look things up in textbooks because they weren't all available on Westlaw. That's changed. That's been a revolution. Um, I can't remember the last time I actually physically went into in a temple library to look up a book. So these things are changing and developing all the time. But if you miss a key directive, a key piece of case law, or in this case, the correct body to give an assurance, I think there's going to come a time when it would be found to be negligent not to do
Hmm.
that.
Yeah.
Oh,
Sorry.
sorry.
Well, I should say Michelle Johnson said I
Ah,
didn't even know co-counsel was an AI tool. I have to say, I have hallucinated in that I've made that up that co-counsel would have spotted that. It's just a hypothesis. So,
assuming that it would.
just to be clear, and
Assuming that it
also,
would.
Francesca and I are guinea pigs, but we haven't actually been testing this yet. So I can't sort of recommend any of these products, but it's worth trying them, I think, and just bearing in mind.
Definitely worth trying. I mean, I don't know how many of you have also seen that Microsoft Word, is it called Copilot?
Copilot, yeah.
They this advert that I saw for this says that it can make your PowerPoint slideshow, for you. You just press the button, it just does it all for you. And I mean, as you can see, my slideshows are not that great, so I'm worried about that. Okay, next one, I think, Connor.
Okay.
Here we go. Okay, let's have the widget.
Um, right. I'll give it another 15 seconds.
Yeah.
All
Okay.
right, there we go.
So
I
here
don't
we've
know if
got
everyone can see that.
almost almost the same split the other way.
Yeah,
Um, now, I disagree respectfully with the majority of you. I think that when one considers that in the lifetime of a consultant radiologist or dermatologist might see 1,000 cancerous moles, but an AI with access to a database of images of cancerous moles from around the world might have access to 10 million images of cancerous moles and will therefore be in a much better position to identify a potentially cancerous mole than the single expertise of the human being. That is a particular area of medical technology where I think a hospital that could have had access to that software but chose not to use it might well be found to be negligent, particularly if there was evidence to suggest that that was technology in widespread use in other hospitals. So it's a qualified answer, but I think it probably would be negligent.
yeah. I think the issue for me is the cost, and I think that's all. As with present negligence cases, it's what's reasonable will often be determined by how much it would cost, and as prices fall, increasingly reliance on this will be expected. Daniel E. Swift says to everyone, um, negligent but assuming radiologist has missed what a reasonable radiologist should have identified. For the avoidance of doubt, in this case, the radiologist wouldn't have, I had meant to say there was nothing negligent because, of course, radiologists, a reasonable one, won't spot 100% of cases. And I think that's where AI can help. Right. Last question then, case study 3. Um, an independent financial advisor uses an algorithm to determine the investment. Sorry, I said independent financial advisor. I should have said investor, but uses an algorithm to determine the investment of client funds. This professional purchased the AI software from a third-party software developer. He does not understand how it works, but has tested it over 1,000 days, and it accurately assesses its prospects for yielding a profit or a profitable trade at 51 to 49. He invests all of his client funds according to the algorithm and loses everything. So I'll do one last poll for this. Um, Sorry, I've been doing these back to front, so this is not poll 1, but obviously it's for this question. And I'll give it another 15 seconds, and then Francesca, I'll let you
Sure.
take us through it. Okay, so
So,
and share results.
just before I come to this, someone said that it would surely be too onerous a duty on the NHS to kit out all of their hospitals with this software. And that, sorry, it's jumping back to the question about cancerous moles. And I think it wholly depends on the cost. So a court will find something to be reasonable or not, but it will come down to the specificity of the cost benefit analysis. And if a hospital can show that it's done that cost benefit analysis and therefore it was right not to use that software because it was too expensive and nobody else was using it, so on and so forth, that will obviously go in their favour. But I don't think it will be too onerous to expect NHS trusts to adopt cheap, effective, reliable software. No, and I think that's going to be an interesting battleground. Coming to this case study, then, slightly less of a 70-30 split, but not actually that far off it. I think the key thing here is going to be that the financial advisor didn't understand how it worked. And I think that would be a red flag to anyone looking at this case. Having tested it over 1,000 days, he's accurately assessed its prospects for yielding a profit at 51.49. That's extremely narrow. I think, again, a court was going to have real difficulty in finding that this action was not negligent in circumstances where using the algorithm was so high risk. And it would look at whether other IFAs were using, firstly, this kind of technology, but also whether they were prepared to bet the house on such a narrow margin. And in particular, in this case, I think it would really depend on whether the IFA had explained to all of his clients what software he was using, what it did, what the results were, and how much risk that they were permitting him to take with their money. And I suppose there might be a really interesting argument about whether or not the IFA could disclaim responsibility for the result if, for example, a client had said, well, I knew there was a 50-50 or close to a 50-50 risk of me losing everything and I was okay with that. I think that would be quite an interesting question, but just on the bold facts of this question, I think it would be negligent.
Yeah, I agree. I think it's about the way the professional has used it here. He just, although I should say, I was seconded to the FCA for a few years ago, and looking, seeing a few interviews with various professionals there. I mean, even when they don't use AI, there are cases where they don't understand what they're doing or the decisions that they're making, and no thought has gone into it. So, and then the second point I'd make about this is the FCA. Again, this comes back to looking at the professional regulators' position on these issues. The FCA has exhaustive guidance on the use of AI and in particular algorithms because it is such a big part of
Trading.
work of so many financial professionals. So again, it's going to be about the standard within the industry and also safeguards, risk management, that kind of thing.
Great. Well, listen, although we have been speaking for almost an hour, it feels like it's gone past in the blink of an eye because we're just so informative and entertaining. So a big pat on our backs, and we even got the technology to work. I mean, come on, guys. We did polls. Thank you all so much for giving up your valuable lunch break to join us. We hope that this has been informative and useful. If you have any questions at all, please don't hesitate to send an email to me and Conor, both of us, one of us, and we'll always be really happy to assist. And I can see plenty of familiar names on the list of attendees. So hi, everyone, and thank you very much for coming. And I think we're going to make a move.
Yeah, thanks, guys. We'll get the slides out to you shortly, and the video will be online for anyone who wants to watch it again and again.
And I'm sure you will want to watch it again
Thanks, guys.
and again. Have a good day. Bye.